Welcome to eDiscovery Leaders Live, where I get a chance to chat with luminaries in eDiscovery and related areas. This broadcast is sponsored by Reveal-Brainspace, the industry's leading AI eDiscovery platform. Don't forget to subscribe to watch me, George Socha, weekly with leaders in eDiscovery. Thank you for tuning in. Welcome to eDiscovery Leaders Live, hosted by ACEDS and sponsored by Reveal. I am George Socha, heading up brand awareness at Reveal. On each episode of eDiscovery Leaders Live, I get the chance to chat with luminaries in eDiscovery and related areas. Past episodes are available on the Reveal website. Go to revealdata.com, select resources, then select eDiscovery Leaders Live. We are broadcasting today live from Toronto, just at the conclusion of the Masters Conference here and from the offices of BLG. And my guest for this episode is Kelly Friedman, who is Senior Counsel and National Leader Beyond eDiscovery at BLG. Kelly, welcome.
Hi, George. Thank you for having me.
Glad to have you here. I would like to start, as I often do, by asking you how you got into this business.
Oh, wow. So I got into this, I was a commercial litigator. This is going back, I was always interested in the evidence issues. And I think when I started off as a litigator, I learned pretty early on that law school failed to teach me something very important, more than one thing, but one thing it failed to teach me was that it's the facts that matter, not the law.
Law school is all about the law.
Law school is all about the law. And then you get into practice. And, you know, I remember running to a senior counsel with a case I thought was going to help so much in the argument he was preparing. He looked at it for maybe 30 seconds and said, it's distinguishable on this fact. And I was taken aback because it was right on point as far as I thought from a law school perspective. And I think it was from that minute, it's the facts. So evidence was always what was important to me. And so in the early days, when I started practicing in the 90s, we were dealing with boxes. I spent a lot of time with boxes. And I was really more interested in document review than most people were, because I thought that is where the need is. If I review documents, I'm going to know more than anybody else. So that's really how it started. A few years into my practice, I was put on a trial. It was supposed to be, I was working on a file. It was a 3-month trial. And the client was adamant, this is not going to settle. It was supposed to start the day after Halloween. So I will never forget that because I had little kids at the time and I was not going to be home for Halloween. That the client insisted that I keep my schedule completely clear for those 3 months. That's really scary for a litigator. And what happened was, lo and behold, the day before it settled. So I had this huge gap in my itinerary.
And in your billable hours.
In my billable hours. I had 3 months. And so I right away started thinking of what kind of business development, what kind of professional development could I start doing to get myself busy and interested. And at the time, there were no eDiscovery conferences in Canada. This was not something that had really reached us yet.
This was what, mid-90s or?
This was end of the 90s, 97, 98, 99, like it just trickling, right? We just started seeing emails popping into things. So I actually did a proposal to the firm I was at the time to send me to New York for an eDiscovery conference because all the good stuff was happening in the US. And from there, I got involved. I ended up getting involved in all the organizations. And so what happened to me, fortunately, I didn't have the awakening that many litigators have. They get interested in eDiscovery because they have a disaster, right? Like they have a huge file. It went wrong. They're now trying to prepare for trial or for discoveries, and it's just difficult. I was lucky in the sense that I got very involved in best practices in theory before it happened to me in my practice. So I actually got really lucky that way. So I never had that eDiscovery disaster to propel me into it. I started learning about it before. And I remember telling my partners at the firm I was at the time what I was doing, and people thought I was wasting my time, right? Well, why aren't you doing more focusing on securities litigation? Or I know you do energy regulation. Why aren't you focusing on energy regulation? That's really big. I was really interested.
Or you're doing eDiscovery. Well, that's computers. Why don't you negotiate contracts with?
Right. You know, no one really saw the benefit and thought maybe I was wasting my time. And I decided, you know what, I'm interested in this, and this is the issue of the future, how we're going to deal with digital evidence. And so, you know, it had already been a topic of much discussion in the US. And so I inserted myself into that discussion. So I became known as Kelly from Canada, right? Because every meeting I went to, I was the only Canadian. So it was easy for people to remember Kelly from Canada. So that's really how I got involved. And then, of course, in my own litigation files, it started popping up. And then I became the go-to lawyer in the firm for whenever there was eDiscovery issues or a big project. Kelly, can you just take over this aspect of the case? So that started happening. So I was a litigation partner, not really with the mandate to run an eDiscovery practice, but it soon became a specialty. And there we are. And then 5.5 years ago, I was recruited to come to BLG and run their eDiscovery business. So I left my litigation practice behind and focused full-time on eDiscovery. And it was quite an easy transition for me because I had been doing so much of that work that really wasn't a ton of stuff to wrap up on my litigation practice and my regulatory practice. And here I am 5.5 years later.
Well, this gives you, this experience and this background gives you a perspective running an eDiscovery function in a law firm that a lot of people in that role don't have.
That's exactly right. And I really found when I first really started managing a team in this area, tried to reinforce, you have to not think of this as data, right? Because what happens with eDiscovery professionals sometimes, and all the technicians, data is data, right? Oh, it's this kind of data, it's that kind of data, it's this format, it's that format. And instead think of it, this is potential evidence that's going to make or break the case. So don't think of it as data, think of it as evidence. And it's extremely important. So, you know, you may think, oh, there's a particular format and or we can't process that properly. Well, you better speak to the litigation team and the client and make sure if there's going to be crucial information in that format that you better figure out how to review it and produce it. So, yeah, that's how I end up where I am and how I try to focus people on the evidence. So I think, you know, it's the litigator first in me, right? The litigator mindset. And that actually brings me to a topic that is just fascinating to me and concerning to me with all the artificial intelligence and the exponential increase in development of all these AI tools is admissibility, getting it into court, how to distinguish fact from fiction.
What's real,
what's real and what's not. I mean, as a Canadian watching US politics the past many years, this idea of fake news started to petrify me that anything that you've done or said that you wish you hadn't, you can then say it was fake. Or
disavow it.
Disavow it entirely. And so I started doing a lot of reading and thinking about it, which is, you know, leads me to people like Professor Maura Grossman, who's an expert in this area, to talk about these issues a lot. So I think that's, to me, you know, I think from the eDiscovery perspective, I have to figure out how to review and incorporate the products of eDiscovery, of artificial intelligence, you know, evidence produced from artificial intelligence, from algorithms. I have to figure out how to do that from an eDiscovery point of view. But I really think ahead. what is happening in court. How are counsel going to prove this evidence? Who are they going to call? How is it going to be challenged? And thinking really down the line that way. So maybe I'm not staying in my wheelhouse as much anymore because I shifted, but
maybe the wheelhouse is just kind of moving to a slightly different place on the boat, or it's in the same place, but the boat's in a different direction. However we want to go.
I think so. I think more than ever, there's no question that when I came into this role, my background as a litigator was extremely important for a couple of reasons. First of all, I understood the mindset of the litigators very, very well. Secondly, hopefully not to offend anyone watching or listening, but litigators are snobby. They're snobby. They want another litigator to advise them, right?
Absolutely.
So, and I was a litigator, but in the sense that there are some absolutely excellent eDiscovery professionals who aren't taken seriously by the lawyers that they advise. And that's because you've never been in a courtroom. Well, you have no idea, how I'm going to get the witness to prove this. And so just by virtue of the fact of having that background, I think I had a better audience. I had a more attentive audience when I wanted to advise on best practices. And often I would give options and say, if this was my case, I would go about it this way. And that has a lot more weight when you litigated for over 20 years.
Right, when you actually had cases.
When you actually had them.
Yes.
So I do think that is really important. On the other hand, I think there are plenty of non-litigator eDiscovery professionals who have so much to offer and say, because what the litigators don't realize is they see so many different types of litigation and different types of evidence and documents that they do have a lot to offer. Yep. Just because they weren't the ones in court trying to proffer the evidence doesn't mean they don't have something to say about it that's valuable. So I do try to break through that snobbery sometimes.
Well, we never tried cases all on our own. We always, in case of any size, there was always a team there backing us up.
Well, that's right.
And doing the things that sometimes we had no ability to do.
There's no question about that. So,
so before we go farther into the deep fake side of things, I've got a question coming out of what you just said.
Sure.
For those eDiscovery professionals who are finding it challenging to be heard, and to be taken seriously, and who don't have the type of background you do, what can they do?
I think they should try to become part of the litigation team, right? Not think of themselves as just an adjunct to the litigation process. Like, I come in, I do my bit, I give you the information, and then you deal with it, right? But find out what the case is about. Understand, get involved in the information governance strategy of the client so you can give better advice on collection, et cetera, and targeting information. So you don't have to have been in the courtroom to show an interest. Read the pleadings. So that's something that always shocked me, that how could an eDiscovery professional properly cull a data set to get at the key documents for the lawyers to review if they really don't know the parameters of the case? Right. How could they do it? And then when I was a litigator and was using external vendors because we didn't have our own tool, they never asked those questions. And that really bothered me. And I was able to step in and kind of perform that role and be the liaison in that way between the litigation team and the eDiscovery vendor. So when I got into the vendor role, internal to BLG, but still the vendor role, I kept that perspective. I don't need to know everything,
but a lot.
I read the pleadings. I talk to the litigation team about strategy. eDiscovery strategy has to be in sync with the overall litigation strategy. Litigation strategy changes and the eDiscovery strategy might have to adapt to that. And so they feed one another. right? What you learn in the context of eDiscovery can change the whole litigation strategy,
Right.
and vice versa. So I don't think it's wise for anybody in the eDiscovery space to think they could be in a silo and just do their thing. I don't think so. And not to say you have to know everything about everything, because there are experts to handle that. But you need to start thinking, what are the facts here? Who are the people, and what's the real impact of this data, right? And when I hear that, oh, it's this data, that data, I'm like, what are we talking about? Are we talking about, a company, in the business of manufacturing a particular product? Is it their emails? Is it their testing data? Is it their accounting information? Right. What are we talking about? What kind of information is this? I don't care just about the formats of the data. I want to know what it is, what the need of it is, or the substance. So I think that you don't have to have had 20 some odd years as a litigator to do the work. I think you just have to develop the interest and ask the questions. Ask the questions so that you can really inform your own work. And you will be a better eDiscovery service provider if you have a handle on the case, and if you recognize that it's real people, real businesses, real economic impact, and it's not just an issue of culling and producing data.
Back now to the data, the information,
the hot topic,
the hot topic, that which is generated with and through AI, and the challenges of dealing with that, as opposed to that which is generated directly by people.
I don't know where we're headed. I think as you get older, you get more and more comfortable with uncertainty. When you're younger, you feel like you need to know everything, and you soon realize when you get into this profession, in the legal industry, and probably in any profession, that there's a hell of a lot you'll never know, and that you don't know, and you become more comfortable saying you don't know. Right. So I could say there's a lot I don't know right now, but I'm particularly concerned with how the courts are going to struggle. We know as eDiscovery professionals that courts have struggled with electronic evidence issues since they emerged, right? And they still, in some you get before certain judges and they understand nothing about the evidence issues, the digital aspects of the evidence.
It wasn't part of their practice. It's the issues haven't worked their way up to them in a way that's required them to learn. So why would they know?
Right. So if they don't have even a handle on what email threading is and how that's changed how we review email and how we produce email, how are they going to grapple with an argument over someone saying, this is a deep fake? This is not my voice. This is not my face. It may look like me and sound like me. And then you have to get into some, real battle of the experts, but probably on each side of the case, many, right? The developers and the designers and the people who collected the data and the people who tested the data. How there are so many ways we can challenge the evidence, which scares me as well, because the truth is going to be under fire. So we are going to have plenty of cases where legitimate evidence is torn apart to the point where decision makers, whether it be a judge or a jury who are deciding on the facts, are bamboozled. And I'm very worried about that, and how we're going to keep up with that. I think, like everything, education, judicial education, education of counsel, but it's been so hard to do that as an eDiscovery professional. How are we going to do it with the artificial intelligence angle that is now ever present? I'm not sure.
The one thing I do know from my many years as an testifying expert witness, the system cannot afford the cost of having to have battling experts on these issues on every matter. That can't be done. So that's not going to work. Ignoring the issue isn't going to work. Where lies hope for us in this?
Well, interesting, a development in the US that hasn't happened in Canada, but we've talked about it. I've been talking about it for at least 15, 20 years and hasn't developed, is this issue of the special master. A master who is specialized in these particular issues. And I think it's really time, and I've been talking about this in Canada, like I said, it hasn't quite caught on, but a special master who is educated in the computer science aspects, and the legal aspects, that intersection that's so hard to understand, that there's so few people who have both some forensic understanding as well as legal understanding. If we had special masters like that to sit in rooms with the parties and really be able to say, you're not bamboozling me with that.
Mm-hmm.
I know exactly what you're saying, and that's really not applicable to this kind of algorithm. And I'll tell you why. We need that. We need the strength of real experts in the capacity of, either whatever you want to call them, junior judges or pretrial judges or masters, but in that capacity, so that before the issue gets to the trial judge, it's been fully fleshed out. And then the judge also has the assistance of a special master to explain things. I mean, explaining things in simple terms is the life of a litigator, right? Just explaining, how would you explain it to a 3-year-old or a 4-year-old or a 6-year-old? Depending on the knowledge of the decision maker, you have to adjust that. And it's going to be very unlikely, at least, in the next 10 years, that we're going to get judges that are expert in artificial intelligence, right? So we need people who can simplify the explanations. And so that's what I would like to see.
Could I play devil's advocate?
You sure can.
With that? The issue of special masters is, as you noted, in the United States, not a new one.
Right.
It's been around for as long as I can remember. We've been using special masters, but they're used typically in a narrow range of cases. I wrote an article, this was probably around 2003, 2005, advocating the adoption of the use of special masters to deal with eDiscovery issues.
There you go. We're ad idem on that issue.
Well, and we were in very much in a similar situation then with eDiscovery generally, as we are with this particular issue now. I heard back from judges. And not a one of them I heard back with thought was that what I was suggesting was a good idea. And I was a bit taken aback. My pride was a little injured. I thought I'd had a good idea. But then I sat back and gave some thought to what they had said. And 2 things in particular stood out for me. One was they said, this really is, as judges, our responsibility. We need to learn how to handle these issues.
Fair.
It's within the scope of what we are expected to do. It's not a fair excuse for us to say it's too complicated, it's too confusing. We have to come to terms with it. Okay? That's easy to say, hard to accomplish.
Right.
Second, they said that litigation, even then, had become very expensive. And many of them felt that it was the expense of it was taking it out of the reach of the average litigant, who was then forced to settle, even if there was no substantive reason requiring them to settle. And they said, at least in the US, a special master is paid for by the parties. The parties already are paying too much to have these issues dealt with. It's going to have an especially negative impact on those parties with the least ability to pay. They said, this is not where we think our legal system should go. I didn't have a response. Now, there are definitely differing points of view. EDRM just put out a paper very much advocating for the use of special masters. So a range of views here, but I took to heart what they said.
It's interesting. I think My response to that, my initial reaction is access to justice has to be their primary focus.
Mm-hmm.
And parties will not get justice if the judge listening to this battle does not understand the issues.
Agreed.
And judges do accept that they're not medical experts.
Mm-hmm.
They accept that. They have
Right.
battles of all kinds of experts in their courtroom, scientific evidence. So
Mm-hmm.
I think that maybe with the eDiscovery piece, they were more reluctant to accept that this is maybe beyond my expertise. Because we are judges, we understand evidence, this is evidence. I think maybe with artificial intelligence, it might be a little bit different.
Mm-hmm.
People aren't as ashamed to say, I have no idea how that's happening. This is the behavior I'm seeing, but it's a black box. What's going on
Mm-hmm.
in it? Even the people who design these algorithms are comfortable saying that.
Right.
So I think it's a bit different. So maybe they'll
Maybe the
pull
time
up
has
that
come.
paper from way back and maybe they'll be more amenable to using eDiscovery masters for pure eDiscovery without
Mhm.
AI issues, which is now going to be unlikely. There are going to be AI issues.
And for people who are contemplating that, I would commend to them the paper put together by that group in EDRM.
Yeah,
recently.
for sure. So something has to happen.
Right.
You are
Yeah.
not, and as well, given the pace of change, there is
Mhm.
absolutely no way to keep the judges up to speed. They have too much. They
Right.
just have too much. Their workload is too much. They're keeping up on the law. They have a lot to do. Judicial ethics. How are they going to keep up on the developments in artificial intelligence so as to adjudicate those kinds of questions? So that's why I think a special master of sort person needs to step in to help. Now, if we can have that funded as part of the court system, that would be wonderful.
Right.
Are we going to be able to do that? Probably not. So I don't know what the solution is, but I don't think in this area it's fair for the judges to say this is in our wheelhouse.
And if we don't even know we have a problem, we're certainly not going to solve it. So the first step is,
Right.
as you've done here,
Yeah.
to identify the problem.
Right. I mean,
try to
and they
figure out where to go.
the answer always to those
Mhm.
to judges saying that is, let's go back to the access to how are we going to do justice?
Mm-hmm.
So they make the excellent point that you can't do justice if things are oppressively expensive and you can't afford to do it. So there's no question that focus is important as well. But the focus of also not being able to analyze the evidence and scrutinize it properly is real now. This is a real problem. Emails, what we dealt with, emails and PowerPoints and spreadsheets, judges at least saw them.
Right.
They were familiar with them.
Yes.
They
Mhm.
used them. They looked at them. They were something that they can wrap their heads around, even if they misunderstood nuances that we wish
Mhm.
they understood. But in artificial intelligence, I don't, it's not familiar.
Maybe.
Only familiar in the sense that we might ask Alexa the time or something, but not familiar in that we know it when we see it, or that, it looks like a duck, acts like a duck, it's a duck.
Mhm.
You actually really do need experts. And I don't know how we're going to fund it, but it's happening. It's something that we really have to pay attention to, because challenging fake evidence is one thing, but challenging real evidence,
Mhm.
actual facts,
Right.
is now going to be, as they say, the liar's dividend or the liar's advantage. Every piece of evidence is going to be able to be attacked as being fake. We see it, in popular culture happening that way, and it's
Right.
going to happen in the courtroom. So I don't know. If you come up with something better than special masters, you can tell me, but that's the concept. But
I don't have anything to throw out there that's better.
Yeah, but frankly, it's a shame Canada hasn't even taken that on in the eDiscovery context. So maybe this is our starting point. You and I could write a paper. And I can write a paper bringing the concept to Canada. There you go. We've got something to publish. How important that concept is now.
Mhm.
more than ever, and then educate judges on that. So you educate them that it is perfectly acceptable for them not to know anything about this area.
Right.
It
Yep.
is. It is perfectly acceptable. It
Of
may not
course.
have felt to them perfectly acceptable for them to not know anything about eDiscovery,
Mhm.
emails and spreadsheets and the like.
Right.
But they cannot be expected. They don't have the time and resources to become experts in this area, and someone needs to do it for us. So,
Well, you've given us a call to action,
yes.
haven't you? Well, Kelly, thank you very much for joining. Kelly Friedman is Senior Counsel and National Leader Beyond Discovery at BLG. I am George Socha. This has been eDiscovery Leaders Live, hosted by ACEDS and sponsored by Reveal. Kelly, thank you so much.
Thank you, George. Wonderful discussion.
Bye.